Welcome to the deep dive. Today, we're tackling something pretty crucial, but honestly, often kind of murky in global commerce.
Yeah, the World Trade Organization rules on subsidies.
Exactly. And we've got some solid sources here looking right at the core agreements. That's the JET 1994 and the big one, the Agreement on Subsidies and Countervailing Measures, the SCM agreement.
Right. And our mission for you, listening in, is really to cut through all that jargon.
Yeah, make it make sense.
We want to give you a clear picture of these international subsidy rules, point out the really important differences, maybe even uncover a few surprising bits along the way.
Think of it as your shortcut, your way to get genuinely clued up on a really key part of global trade without getting bogged down.
Absolutely. So what we're going to cover is, first, how the WTO even defines a subsidy.
Okay.
Then the big difference between subsidies that are just flat out banned, the red light ones, and those that could be a problem, the actionable ones.
And how countries can fight back, right? These countervailing measures.
Yeah, we'll get into that. And also touch on the special rules for developing countries and for agriculture, which is always its own beast.
Sounds like a plan. Let's dive in then.
Okay, so first things first. What is a subsidy in the eyes of the WTO? Super important right off the bat to get that WTO law sees subsidies way differently than, say, dumping.
Right, dumping isn't actually prohibited, is it? But subsidies can be.
Exactly. Some subsidies are banned outright. Others, well, they can be challenged if they cause trouble.
So what makes something a subsidy? Our sources talk about two main things needing to be there.
That's right. Two essential elements. First, you need what they call a financial contribution from a government, or maybe some kind of income or price support.
Okay, government money or support.
And second, this is crucial, it has to actually give a benefit to whoever receives it.
Financial contribution and a benefit. Got it. Let's dig into that financial contribution bit first. What forms can that take?
Well, Article 1.1 of the SCM agreement spells it out pretty clearly. It can be, direct transfers of funds, things like grants, loans, even the government taking a stake, like equity,
So cash or loans?
or even potential transfers, like loan guarantees.
Yeah.
But it's broader than just that.
Okay, how so?
It also covers situations where the government doesn't collect revenue it normally would. Think tax breaks, tax exemptions. That counts.
Ah, foregone revenue. Makes sense.
Yep. Then there's the government providing goods or services other than, general infrastructure like roads, or the government buying goods.
So cheap materials or the government being a guaranteed customer?
Could be. And finally, it includes if the government makes payments into some kind of funding pot, or even uses a private company to deliver the financial contribution but directs them to do it.
Wow, okay, so they really try to cover all the angles? It's not just obvious handouts?
Exactly.
Oh.
The definition is deliberately broad to stop countries from finding easy loopholes.
Okay, what about the other part of that first element, income or price support? Does that mean any government action that just happens to affect prices?
No, not quite. Article 1.1A2 is more specific. It's about direct government action in the market with the specific goal of setting or keeping the price of something at a certain level.
So not just like a general policy that might indirectly push prices down. It has to be deliberate price fixing.
Pretty much. It's a direct intervention to manage the price itself.
Understood. Okay, so that's the financial contribution or price support. Now, the second key element, the benefit. What does that mean here?
Simple idea, really. A benefit exists if the company, the recipient, is basically made better off than they would have been without that government help.
Better off how?
Article 14 gives guidance. Essentially, did they get the contribution on better terms than they could have found in the normal market?
Ah, like a loan with interest rates lower than any bank would offer.
Exactly. If the terms are more favorable than what's commercially available, then yes, a benefit has been conferred.
Okay, let's make this concrete. Our sources used this Agricola chocolate example. Walk us through how those government actions fit the definition.
Sure. So Agricola's government gives loans to chocolate makers at below market interest. That's a direct transfer.
Financial contribution.
On better terms than the market.
Benefit. Check.
Then the government provides cocoa powder cheaply. That's government providing goods
Financial contribution.
at a price better than they'd find otherwise.
Benefit. Check again.
Okay, how about the free lab testing for cadmium?
That's the government providing a service for free.
Right, a financial contribution,
Yep.
because it saves the producers money they'd otherwise have to spend.
Which is definitely a benefit. Check. And the last one, Buying chocolate for hospitals at inflated prices.
That's government purchasing goods
Financial contribution.
at above market price.
Benefit. Okay, I see how each piece fits both parts of the definition. It's not just about cash.
Exactly. It's any advantage the market wouldn't normally provide coming from the government.
Right, so we know what a subsidy is, but you mentioned the WTO doesn't go after every subsidy. There's this idea of specificity. What's that about?
Yes, specificity. This is really key. The SCM agreement. It mainly targets subsidies that are specific,
Meaning,
meaning they aren't available broadly across the whole economy. They're targeted.
why only those?
Well, the thinking is that really broad subsidies available to everyone are less likely to mess up how resources are allocated or seriously distort trade. It's the targeted ones that raise concerns.
Okay, so how do you tell if a subsidy is specific? Article 2.1 apparently lays out some principles.
It does. Three main ways to determine specificity. First and simplest is if the government body giving the subsidy explicitly limits who can get it.
Like the law says only for car manufacturers.
Precisely. If access is limited by law to certain companies or industries, it's specific. That's 2.1a. Straightforward.
Okay, what's the second principle?
The second one, 2.1b, says a subsidy is not specific if the rules for getting it and how much you get are based on objective criteria.
Objective criteria.
Yeah, things that are neutral, economic in nature, clearly spelled out, and crucially, applied automatically. If you meet the criteria, you get the subsidy. No funny business, no discretion.
So like a tax credit for any company that invests a certain amount in R&D if the rules are clear and applied to everyone who qualifies.
Exactly. If it's automatic, based on objective criteria, strictly followed and well documented, it's generally not considered specific.
Okay, but there's a third way, right? Something about de facto specificity.
Yes, the tricky one. Article 2.1c. This says, even if a subsidy looks non-specific based on those first 2 points.
Even if the law seems general.
Right. It can still be found specific de facto, meaning specific in practice by looking at other factors.
Like what factors?
Things like, well, does only a very small number of companies actually use the subsidy program? Or maybe just a few companies get the lion's share of the benefits.
So who actually gets the money matters even if the rules seem broad.
It can, yes. Or if disproportionately large amounts go to certain companies. Also, how much discretion the government officials have when they're handing out the subsidy that's considered too.
That does sound a bit fuzzier. How easy is it to prove that?
It could be more complex, requiring more evidence about the actual distribution and operation of the program. But it's designed to catch situations where the rules look neutral, but the reality is targeted support.
So it prevents governments playing games with the wording.
That's the idea. And Article 2.2 adds that subsidies limited just to certain geographic areas within a country are also specific.
Like only for companies in a specific state or region?
Exactly. And one more important point from Article 2.3, all those red light prohibited subsidies we mentioned earlier, they are automatically considered specific. No need to even analyze it.
Okay, that simplifies things for the banned ones, and you said the main focus is on who can get it, not just who does.
Yes, the core of the specificity test is about limitations on eligibility. Is access limited? That's the primary question.
Right. Let's go back to industry's examples. The smartphone loans.
Interest-free loans, but only for smartphone producers. That's a textbook explicit limitation. Specific under 2.1a. Clear cut.
Okay. What about the R&D tax reduction? The one only 2 big firms actually qualified for.
That's where de facto comes in. The rule sounds objective. Invest 25% of profits in R&D. But if, in reality, only 2 huge smartphone companies can meet that threshold.
Then it looks like it's targeted at them, even if not explicitly stated.
Exactly. It strongly suggests de facto specificity under 2.1c because it predominantly benefits or is by a very limited group.
Makes sense. And the cheap electricity for all small businesses.
Assuming the definition of small and medium-sized enterprise is objective, the criteria are clear and it's automatically available to any SME that meets them, regardless of industry.
Then that sounds non-specific.
Correct. It seems to meet the criteria in 2.1b for being generally available, not targeted.
Okay, phew. So we've got subsidies defined, and we know the WTO focuses on the specific ones. Now, let's get to those red light ones, the ones that are totally forbidden.
Right. The prohibited subsidies under Article 3. These are the ones the WTO really cracks down on.
And they are.
2 main types. First, export subsidies. These are subsidies that are contingent or conditional on export performance.
So you only get the money if you export.
Basically, yeah. or you get more money the more you export. The second type is import substitution subsidies.
Ah, the ones that reward using local goods instead of imported ones.
Exactly. Subsidies contingent on using domestic over imported goods. Article 3 says both types are prohibited. Full stop.
That word contingent seems pretty important there. What does it mean legally?
It just means conditional or dependent upon. The subsidy relies on the company either exporting or using domestic inputs.
And this can be obvious, like written in the law.
Yes, that's de jure contingency. It's right there in the legal text. Or it can be de facto.
Like the specificity thing. Not written down, but clear in practice.
Exactly. It's not explicitly stated, but looking at how the subsidy actually works, it's clear it's tied to exports or using local goods.
So, hang on. If a company exports 90% of its production and it gets some government subsidy, does that automatically make it a prohibited export subsidy?
No, absolutely not. That's a common misconception.
Yeah.
Just being an exporter and getting a subsidy isn't enough.
There needs to be a link.
A clear link. The subsidy has to be granted because of the exports or somehow conditional on them. The standard for de facto contingency is whether the subsidy is, and I quote the appellate body here, geared to induce the promotion of future export performance.
Geared to induce. Okay, so it's about the purpose and likely effect.
Yes, viewed objectively based on all the evidence.
And for the import substitution ones, it has to be an actual requirement to use domestic goods, not just like an encouragement.
That's right. The appellate body was clear. Making the subsidy conditional on using domestic over imported goods is the key. It has to be a condition, not just a possible outcome.
So why are these two types banned outright? What makes them so bad in the WTO's view?
Because they are seen as inherently trade distorting, they directly interfere with normal market competition.
How so?
Well, export subsidies basically help companies dump their products cheaply on foreign markets, hurting producers in those countries. And import substitution subsidies are pure protectionism, walling off the domestic market.
So they're seen as directly aiming to distort trade flows and likely to harm other countries.
Precisely. That's why they get the red light treatment.
And if a country gets caught using these, what happens? Is it just a slap on the wrist?
Oh no. Article 4 kicks in with much faster dispute settlement timelines. We're talking maybe half the normal time.
Faster justice.
And if the panel rules against the subsidizing country, the recommendation is simple. Withdraw the prohibited subsidy without delay. They'll set a deadline.
And if they don't withdraw it,
Then the complaining country can ask the dispute settlement body to authorize appropriate countermeasures.
like retaliation, tariffs.
Yes, but interestingly, for prohibited subsidies, the countermeasures can be linked to the amount of the subsidy itself, not necessarily just the level of trade damage caused, which is the usual approach.
Okay, so serious consequences for breaking these fundamental rules.
Yeah.
But most subsidies aren't prohibited, right? They fall into this actionable category.
Exactly. Most subsidies aren't automatically banned. These are covered by Article 5. They can be challenged, but only if they cause adverse effects to the interests of another WTO member.
So they're innocent until proven harmful, basically.
That's a good way to put it. The burden is on the complaining country to show harm.
And what counts as adverse effects? What kind of harm are we talking about?
Article 5 lists 3 types. First, and maybe most common, is injury to the domestic industry of another member country.
Injury to their local companies.
Yes, specifically the industry producing the like product, meaning the same product, or one very similar.
How do they measure that injury?
It's very similar to anti-dumping rules. They look for material injury, or a threat of it, and crucially, a causal link. Did the subsidized imports cause the injury?
Okay, so subsidized imports hurting local competitors. That's type 1. What's the second?
The second is nullification or impairment of benefits another member expected under the GATE agreement.
Nullification or impairment. Sounds complex.
Think of it this way. Countries negotiate lower tariffs, expecting better market access. If another country then uses a subsidy that effectively cancels out the benefit of that lower tariff.
Ah, so the subsidy undermines the deal they made on tariffs.
Exactly. That expected benefit is nullified or impaired. That can be challenged.
Okay. And the third type of adverse effect.
This one's called serious prejudice to the interests of another member or the threat of it.
Serious prejudice. Sounds serious. What does it cover?
Article 6.3 gives examples. It could be things like the subsidized product pushing out imports of a similar product in the subsidizing country's own market,
So blocking imports.
or displacing another country's exports in a third country market.
So stealing export sales elsewhere.
Right. It also includes stuff like significant price undercutting the subsidized goods are way cheaper, or causing prices generally to be suppressed or depressed, or evidence of lost sales.
Our sources flagged the big Airbus-Boeing case here, EC, large civil aircraft, that related to serious
Oh
prejudice.
yeah, massively. That was a huge fight over subsidies the EU gave to Airbus.
And the U.S. complained it caused serious prejudice to Boeing.
Exactly. The WTO panels looked at things like displacement. Did Airbus sales boosted by subsidies like launch aid push Boeing planes out of markets like, say, Australia?
And did they?
The panel found evidence, yeah. They saw Airbus's market share shoot up in Australia while Boeing's dropped by a similar amount, linking it to the subsidies.
Wow. Any other findings?
They also found specific instances of lost sales. Airlines like EasyJet, Qantas, campaigns where they ultimately chose Airbus over Boeing, and the panels linked that decision, at least in part, to the effects of the subsidies.
So concrete evidence of market harm was key.
Absolutely. Based on that displacement and lost sales evidence, they concluded serious prejudice existed.
So what happens if a panel does find an actionable subsidy is causing adverse effects like injury or serious prejudice?
Well, Article 7 outlines the process. The dispute timelines are again a bit shorter than normal WTO cases, but not as lightning fast as for prohibited subsidies.
And the outcome?
If adverse effects are confirmed, the subsidizing country gets a choice. Either they take steps to remove the adverse effects,
Like change the subsidy so it stops causing harm.
or maybe offer compensation, yeah. Or their other option is just to withdraw the subsidy altogether,
And they get a deadline.
usually about 6 months. If they don't do either remove the effects or withdraw the subsidy, then the complaining country could be authorized to impose countermeasures.
Retaliation again.
Yes, but here the countermeasures have to be commensurate, meaning proportional to the level of the adverse effects found.
Okay. Now, what about that follow-up Airbus case mentioned? The one about expired subsidies.
Ah, yes, the Article 21.5 compliance panel. That was interesting.
What was the issue?
The question was, if a subsidy program has ended, it's expired, but maybe its harmful effects are still lingering in the market, can the WTO still order the country to withdraw the non-existent subsidy or remove its past effects under Article 7?
And the answer was?
The appellate body said no. The obligation under Article 7 attaches to the subsidy itself. If the subsidy no longer exists, you can't order its withdrawal. And you can't order the removal of past effects under that specific article, even if those effects linger.
So once the subsidy is gone, that specific remedy under Article 7 is off the table for past harm. That's important.
A very important clarification.
Okay. Our sources also briefly mentioned non-actionable subsidies. Is that still a thing?
Mostly no, not anymore in the way it was originally intended.
What was the original idea?
For a while, until the end of 1999, Article 8 created a sort of safe harbor for certain specific subsidies that met strict criteria.
Specific, but still okay. Like what?
Things like subsidies for regional development in disadvantaged areas, help for companies adapting to new environmental laws, and support for research activities. Under tight conditions, these were non-actionable, meaning they couldn't be challenged even if they were specific.
Why did that end?
Well, the provision expired, and members couldn't agree to renew it. There were debates about whether it was really working or if it was being used as a loophole for industrial policy.
So what's non-actionable now?
Pretty much only non-specific subsidies. Those are outside the SCM agreement's scope anyway.
Yeah.
Those specific subsidies that used to be in the safe harbor for environment, R&D regions, they're now potentially actionable if they cause adverse effects.
Okay, so the landscape is basically non-specific subsidies are fine. Specific subsidies are either prohibited outright or they're actionable if they cause harm.
That's a good summary of the main categories, yes.
Now, what if a country isn't launching a big WTO case, but its own companies are getting hammered by cheap subsidized imports right now? Can they do anything themselves?
Absolutely. This is where countervailing measures come in. It's a unilateral tool.
Unilateral meaning the country can act on its own.
Yes, under its own laws, but following WTO rules. Article 6 of T and Part V of the SCM agreement allow a country to impose special import duties, countervailing duties on imports that are subsidized and causing injury to its domestic industry.
So an extra tariff just on those subsidized goods.
Exactly, to level the playing field.
What does a country need to show to justify imposing these duties?
3 key things, very similar to proving injury in an actionable subsidy case at the WTO. First, the imports must actually be subsidized and specific, according to the WTO definitions we discussed Articles 1, 2, and 14.
Okay, prove the subsidy exists. Second.
Second, the domestic industry making the like product must be suffering material injury or be threatened with it. Articles 15 and 16 cover how to determine that.
Prove harm to local producers. And third,
Third, a causal link. You have to show that the subsidized imports are the cause of the injury, not other factors like, say, falling demand or competition from non-subsidized imports. Article 15.5 is crucial here.
subsidization, injury, causation, the big three.
Yep. And the process for figuring all this out, the investigation, also has rules.
Like anti-dumping investigations.
Very similar. Articles 11, 13, and 22 lay out procedural requirements, how to initiate the case, conduct the investigation, ensure transparency, give parties a chance to defend themselves. It's quite detailed.
And if they go through all that and find, yes, subsidized imports are causing injury, what are the rules for the duty itself?
Several important rules in Articles 19, 21. First, the duty cannot be higher than the calculated amount of the subsidy per unit.
Can't be punitive, just offsetting.
Right. Second, it should only stay in place as long as needed to counteract the injury. There have to be periodic reviews.
And doesn't last forever.
No, there's a sunset clause. Duties normally expire after 5 years, unless a review shows that removing them would likely lead to both subsidization and injury continuing or recurring.
Okay. Any other limits?
Yes, the lesser duty rule. Ideally, if the level of injury is actually less than the subsidy margin, the duty should be limited to just offsetting the injury.
So the lower of the two numbers.
That's the principle. Also, very important. No double remedies. You can't slap both anti-dumping duties and countervailing duties on the same imports to offset the same situation of subsidization.
Right. Can't penalize twice, for one thing.
And the duties have to be applied fairly non-discriminatorily to imports from all subsidized sources found to be causing injury.
Our source mentioned a couple of other things besides definitive duties. Provisional measures.
Undertakings.
Yeah, during the investigation, if there's a preliminary finding of subsidized injury, the country can impose provisional duties temporarily to prevent further harm while the investigation finishes.
Like a temporary measure. Exactly. And voluntary undertakings are an alternative way to resolve the case.
How do they work?
Instead of duties being imposed, the government of the exporting country might agree to get rid of the subsidy or limit it. Or maybe the exporters themselves agree to raise their prices to eliminate the injury. If the importing country accepts the undertaking, they suspend or terminate the investigation.
So a negotiated settlement instead of duties.
Essentially, yes.
And it sounds like these unilateral duties or undertakings, plus the multilateral countermeasures from a WTO dispute, those are basically the only approved ways to respond to another country's subsidy.
That's what Article 32.1 says. Those 4 options: voluntary undertakings, provisional duties, definitive duties, and WTO-authorized countermeasures are it. No other specific actions allowed against another member's subsidy under the WTO agreements.
Can a country try both routes at once? Like start a countervailing duty investigation and take the case to the WTO?
Yes, they can run both procedures in parallel, but ultimately they can only apply one remedy for the same subsidization, either the domestic countervailing duty or the multilateral countermeasure, not both.
Okay, that clarifies the response options. Now, we know the world isn't uniform. Developing countries often face different challenges. Do the subsidy rules account for that?
They do. Article 27 provides special and differential treatment. It acknowledges that subsidies might be necessary tools for economic development.
So how are the rules different for them?
Well, a key one is the exemption from the ban on export subsidies for the least developed countries, LDCs, and also for other developing countries until their GNP per capita hits $1,000.
So they can use export subsidies.
Yes, but those subsidies don't get a totally free pass. They become actionable instead of prohibited. So they can still be challenged if they cause adverse effects.
Okay, so more leeway, but not unlimited. Anything else?
There are some specific subsidies related to privatization programs in developing countries that are considered non-actionable under certain conditions. And there are higher thresholds, de minimis levels, before countervailing duties can be imposed on imports from developing countries.
Higher thresholds.
Yeah, generally, you can't impose duties if the overall subsidy level is 2% or less of the product's value, or if the volume of subsidized imports from that country is less than 4% of total imports of that product.
Unless
Imports from several developing countries, each below the 4% threshold, collectively account for more than 9% of total imports.
So protecting them from nuisance cases, but still allowing action if the collective impact is significant.
That's the balance they tried to strike, giving them policy space to grow.
Right. Finally, let's talk agriculture. Always a special case in trade, it seems.
Definitely. Agriculture has its own agreement, the Agreement on Agriculture, and its rules prevail over the SCM agreement if there's a conflict.
So, different rules for farm subsidies. How did export subsidies work there?
Historically, agricultural export subsidies weren't banned like industrial ones, provided they were listed in a country's commitments and subject to reduction targets.
That changed.
Big time. At the Nairobi Ministerial Conference in 2015, WTO members actually agreed to eliminate agricultural export subsidies altogether.
Wow, really? All of them?
Yes. Developed countries had to get rid of most immediately, while developing countries got longer phase-out periods, mostly ending around 2018, with a few exceptions.
So that's a major shift towards leveling the playing field in farm exports, too. What about domestic farm support? Subsidies paid directly to farmers.
That's also covered by the Agreement on Agriculture. Countries committed to reducing their overall trade-distorting domestic support, measured by something called the Aggregate Measurement of Support, or AMS.
Reduce the overall distorting support, but are there exceptions?
Yes, large categories of domestic support are exempt from reduction commitments because they're considered less distorting. These fall into different boxes. Yeah, the green box, the blue box, and the development box.
Okay, what's the green box? Sounds harmless.
That's the idea. Green box subsidies are supposed to have minimal or no trade distorting effects. They're not linked to current production levels.
Examples.
Things like government spending on general services research, pest control infrastructure, also public stockholding for food security, domestic food aid, disaster relief payments, environmental programs, regional assistance programs. Lots of things fall in here if they meet the criteria.
So, general support not tied to producing more stuff. What about the blue box?
Blue box subsidies are also exempt, but they are linked to production. However, they are programs that require farmers to actually limit production.
Paying farmers not to produce or to produce less?
Kinda, yeah. Direct payments under production limiting programs.
And the development box?
That provides extra flexibility specifically for developing countries to support their agricultural and rural development needs, food security, etc. It might cover things like investment subsidies or input subsidies for low-income farmers.
Okay, so even with agriculture, while there's still support allowed, the WTO framework tries to steer it away from the most trade-distorting types, especially export subsidies, and put some limits on domestic support, too.
That's the goal, yes.
Yeah.
Trying to create fair competition in farm trade as well.
Well, that really was a deep dive. I feel like we've covered a huge amount of ground.
We definitely have, from, the basic definition of a subsidy
Financial contribution plus benefit.
to that crucial difference between the prohibited red light ones and the actionable ones that depend on proving harm.
Injury, nullification, serious prejudice.
Then how countries can use countervailing duties unilaterally, but within rules.
Subsidization, injury, causation.
And finally, those special rules for developing countries in agriculture.
So hopefully, for you listening, this complex area feels a bit less complex now.
Yeah, you should have a much more solid handle on this really vital part of international trade law. It's tangled, but hopefully we've straightened out the main threads for you.
Absolutely. And just to leave you with something to chew on, think about today's world.
Yeah.
We've got this rapidly changing global economy, right? New tech, huge pushes for green energy, supply chain shifts. Governments are getting involved in new ways.
True. Lots of new kinds of support programs emerging.
So the final thought is, how might these established WTO subsidy rules, which we've just unpacked, how might they cope? Will they need updating to deal with these new forms of government intervention?
That's a really interesting question. Are the existing definitions and categories flexible enough?
Or will we see more disputes testing the boundaries? Maybe think about examples you've seen in the news or even in your own field. How do they fit or maybe strain this framework we've discussed?
Something to definitely keep an eye on.
Indeed. Well, thanks for joining us for this deep dive.